If you're going to be an effective media manager, it is going to be critical that you are aware of the laws, regulations, and ethics that govern your business. The Federal Communications Commission and Federal Trade Commission govern almost everything we do in the media industry. These appointed bodies set the standards by which we may communicate and exchange products and ideas. Even prior to the advent of the Internet, these rules were constantly changing. Today, thanks to the World Wide Web, the rules are changing even faster. Keep up, because ignorance of the law is not a defense. Before we begin, let's talk about the First Amendment and what it provides and what it does not provide. First, the First Amendment provides almost absolute protection to speech directed at influencing governmental policy. Second, it holds that public officials and public figures cannot win a libel suit unless they can offer clear and convincing proof they were victims of false and defamatory assertion of fact. More on this in a minute. Third, the First Amendment extends protection to truthful advertising of legal products or services. Fourth, it should be noted that the First Amendment holds that broadcasters have less protection than print mediums because they must be licensed by the government to use public airwaves. Newspapers and magazines are private businesses. Anyone with enough money and willingness to take the risk can start a newspaper or magazine. Broadcast stations may be privately owned, but because there are only so many air channels, the airwaves are public and are assigned by a government agency, the FCC. And finally, there is no First Amendment protection for obscene materials, fighting words, false or misleading ads, acts of illegal products or services, and language that incites illegal acts. The difficulty here is community standards. What one person views as obscene or fighting words, another may not. This is where it gets tricky, and the courts must make decisions. The First Amendment guarantees us the right to free speech and free press. That doesn't mean we don't have any limitations, obviously, but it means the government has a harder time regulating what we say and print. One protection we have in the media is against prior restraint, meaning the government cannot prevent media outlets from publishing or broadcasting information except in very extreme circumstances. One of the things we cannot do in the media is defame others through libel or slander. It should be noted that I do not have to directly say a person's name to defame him or her. The individual's identity could be implied, as in if I said something false and negative about the mayor of Warrensburg without mentioning the person's name. It should also be noted that opinions or criticisms do not count, so long as it's clear that the information is not being reported as fact. It is very difficult to sue for libel in this case. Here you see a definition of libel. Let me be clear about something here. Even in broadcasting, the crime is libel, not slander, because the script is written before it is read on the air. On point C, if you are reporting that the police have charged an individual with a crime, that is not libel. But if you print that a person committed a crime before that person has actually gone to trial and been found guilty, that is when it becomes libelous. Libel is the most common type of litigation facing media organizations. Why? Sadly, because people get careless, they don't check facts, and they fail to cite official sources. This could also be because more and more media organizations have cut back on staffing, and so potentially libelous statements that were once caught and corrected before publication are now slipping through the cracks. Libel is a tort that is tried in civil court, not criminal court. One thing that could make it more difficult for you as a media manager to navigate is that procedures and punishments vary from state to state, so when you get the job, bone up on your state's rules. The absolute defense for media outlets in a libel case is truth. If what you reported is true, no matter how embarrassing or defamatory, the plaintiff does not have a case. When it comes to public figures, New York Times versus Sullivan set the precedent that the public figures, because they put themselves in the public eye, have a higher burden of proof that libel has occurred. Sure, they can prove that you said it and that it was false, but they really have to prove that it damaged their reputation or embarrassed them to the point of defamation. Because we expect media organizations to have fail-safes and checks and balances, blame in libel cases goes up the chain of command. A reporter might have written the story, but we expect that it has been copy-edited and fact-checked, again more difficult today with leaner staffs, and that editors have given final approval. Now, what that means for the reporter is, if I get busted as your managing editor for something you wrote, you probably aren't going to be around long. As media outlets, we often pay for wire services to provide content as well. And because we expect those wire services to edit and fact-check the work, the law holds them responsible if libel does occur, not the media outlet utilizing their content. Another area of the law we focus on in the media is privacy. The court gives us some flexibility under the First Amendment because it is our job in the media to report news that is of importance or interest to the public. But the key thing we have to keep in mind is that whatever it is we are publishing or broadcasting must be of public need or interest. The fact that Angelina Jolie had a double mastectomy because she had a history of breast cancer in her family is of public interest because she is a public figure and she has chosen to go public with her decision in order to be an advocate for regular mammograms and screenings. If my mother, who is a breast cancer survivor, went in for a mastectomy and you chose to film her and wrote an expose of her experience, you'd have a harder time proving you didn't invade her privacy because she is a private citizen. So what is privacy? We see stories all the time that seem like the reporter has invaded someone's personal space. Well, there are 4 categories. Intrusion is the most obvious. It's when you encroach on someone's personal space, as in trespassing or coming onto private land to take photographs or video. There are some gray areas here. For example, if you are in a car accident, while you are being attended on the ground by your car, you are still in public space and can be filmed. Once you enter the ambulance, I can film from outside the ambulance, but if I step on the bumper to film, I've encroached on your space. Or if you are in your home and you have a big picture window and I can see you smoking a joint, I can stand in the street with a normal focal length camera and take your picture. But the moment I step in your yard, or when I climb a tree and snap on my 300mm lens, I've invaded your privacy. False light is the second category. This is where we present someone in a manner different from who they are. For example, I am given a talk to high school students about the dangers of marijuana and I hold up what looks like a joint. When you take a picture of me doing this and run the photo with a caption about me doing drugs with high schoolers, that's presenting me in a false light and is an invasion of privacy. The third category of privacy is appropriation, which is when you take someone else's name, characteristics, or likeness and use them for commercial benefit without that person's permission or knowledge. It would be me running a video of David Letterman and saying he endorses our digital media production program. And finally, embarrassing facts. This is when you print or broadcast private facts about a person that a reasonable individual would find embarrassing. Again, public figures who are newsworthy have a harder time suing on these grounds, and if the act occurred in public you are already identified, you will have more difficulty suing. For example, if I had been expelled from the university for plagiarism, I never was, mind you, I think we will all agree that would be pretty embarrassing. You find out and decide to report on it. I could sue for invasion of privacy. I'm not a public figure, and there was no big courtroom drama, so it didn't play out in public. Now, if I had just won an award for journalistic ethics, this embarrassing act suddenly becomes newsworthy, so my defense becomes very shaky. Here you can see a descending scale of privacy protection. At the bottom, criminals who have been stripped of most of their rights and by their wrongdoing have waived their right to privacy. Next are public officials because their actions determine public policy and because any government employee or elected official voluntarily places themselves in the public arena. Next up are public figures such as Jesse Jackson, Al Sharpton, Rush Limbaugh, or your evening news anchors. Fourth are celebrities, and so on and so forth. As you decide to report on individuals farther and farther down the chain, you need to more carefully examine if the story is in the vital public need or interest. Antitrust law is intended to promote free competition in the marketplace by outlawing monopolies. It prevents owners of colluding or working together to make backroom deals that benefit them and their shareholders, but hurt the consumer or other small businesses. This is done because competition serves customers and advertisers. If they have options, customers can find the best product for their best price for their needs. And this also allows advertisers to target their message to the appropriate audience. In order to prevent monopolies, government approval is needed more and more for media mergers. This prevents one corporation from owning too many outlets and thus controlling the message that is distributed. Copyright law offers the creator of written, musical, artistic, and architectural materials control over their creations so others may not profit from the creator's work. Some things to keep in mind. 1. The material must be in fixed or tangible form. Ideas are not covered. 2. The material is copyright protected for the life of the creator plus 70 years. 3rd, copyright material is taxable and transferable. And 4th, there is no international copyright laws. For more information, you can go to www.copyright.gov. FCC regulations also cover ownership as the FCC determines who can and cannot have broadcast media outlets and on what frequencies they may operate. It also oversees political communication. Something to keep in mind is that outlets must give priority to political ads and they must sell them at the going rate. No jacking up prices during campaign season. Two rules to keep in mind are the Fairness Doctrine and Equal Time Rule. The Fairness Doctrine was established in 1949 and required broadcast media outlets to devote a part of their airtime to discussing controversial matters of public interest and to provide contrasting viewpoints. The reason being, the scarcity of broadcast spectrum and thus the limited opportunity for access to the airwaves. The doctrine was eliminated in 1987 because of an increasing number of cable television channels, public access channels, and the Internet. The Equal Time Rule, meanwhile, specifies that U.S. radio and television broadcast stations must provide an equivalent opportunity to any opposing political candidate who requests it. This means, for example, that if a station gives 1 free minute to a candidate in prime time, it must do the same for another candidate who requests it. It doesn't mean the station must go solicit the time. And last, the FCC governs indecent content, determining what is indecent and what may be broadcast and when. The Federal Trade Commission protects the public from misleading or deceptive advertisements. Some things you need to keep in mind. Companies must show products as they truly are and not alter them or the results of these products for demonstration purposes. Some puffery is allowed. Puffery is a promotional statement or claim that expresses a subjective rather than objective news which no reasonable person would take literally, such as calling a restaurant's hamburgers the best in the world. Endorsements must reflect the honest views of the people endorsing the product, and these individuals must actually use the product at the time of the endorsement. Testimonials, on the other hand, are often delivered by paid actors who do not even use the product. Also keep in mind that when making comparisons in ads, consumers need to be able to verify the claims made. Do not disparage or unfairly attack the competitor. Research data should be verifiable and should not be false or misleading. And truth in lending laws require all credit terms to be fully disclosed when advertising any type of loan. Shifting gears, let's talk a little ethics. Ethics are the moral precepts held or rules of conduct followed by individuals and cultures. They are often established by religion, generally agreed upon assumptions, or standard practices. It is important to note they are not laws, and they are not always clear choices. As a media manager, you are going to have to determine what your personal ethical standards are, you're going to have to look at the codes of ethics for your specific career fields, and you're going to have to think about how you will make ethical decisions. Moral reasoning, then, is how individuals use logic and reasoning to solve moral and ethical problems. As you practice moral reasoning, think about these 8 questions. Here again is why we begin this class with a chapter on managerial decision-making. Almost every decision you make is going to be based at least in part on weighing the costs and benefits, the harm versus the good. And finally, let's talk a little bit about how to prevent or at least mitigate any legal problems. In order to prevent legal problems, it is going to be important for you to document everything. Keeping a record will help you avoid ugly entanglements down the road. It won't prevent it, but it will help you. First, provide written job descriptions and expectations. You need to evaluate job descriptions periodically, getting employee feedback so these are realistic. Provide evaluation procedures and standards. Let your employees know on what they will be critiqued, and make sure these evaluations are consistent, providing both written and verbal evaluations with measurable options such as deadlines and fact-checking. And with your employees, you need to set goals and provide training. It is in your best interest to provide training for employees if they are deficient in some area or another, or if you are innovating and bringing in new technology or procedures. It is also going to be important for you to train your other managers to conduct evaluations so there is consistency among departments. You also need to be detailed and specific in evaluations so your employees are clear on their strengths and their areas of improvement. You want to get employee signatures, to provide a copy to the employee and to keep one in your employee file, and to follow up with face-to-face conversations. And you will want to develop progressive disciplinary procedures. You will only want to leap straight to termination in extreme cases. This means you'll usually want to begin with a private meeting with the employee, followed by a verbal warning with another manager present. Next comes a written warning with a copy for you and for the employee, and finally, dismissal. Now, something to keep in mind. When terminating employees, have several supervisors review the case beforehand, require an exit interview by the employee, and hold the meeting in private. You want to do this with as much dignity as possible while also protecting yourself. You also are going to need to be mindful of and understand cultural differences among your employees. We have a tendency to think the world should adapt to us, but the best managers recognize that individuals from different backgrounds or cultures communicate in different ways, and if you're going to operate efficiently and legally, it is important to, quote unquote, speak their language. You can also help avoid legal issues by using arbitration or mediation when needed to settle dispute. It may sound like an invasion, but it is not a bad idea to monitor employee emails, or at least to have your IT people do so. By doing so, you may uncover and remove any obscene or pornographic materials that, yes, affect the employee status with the company, but for which you may also be liable. Finally, have your legal team review all advertisements before they are submitted in order to prevent false or deceptive ads. Remember, FCC regulations forbid this. I know it is tedious. I know legal matters are uncomfortable and they can be confusing. Educate yourself as much as you can, and then seek the wisdom of your legal team.